performance is an equitable remedy under Section 4, Subsection B of Specific Relief Act 1950. It is allowed the court to compel a party to carry out their contractual obligation. Because it is discretionary, the court will only grant it when it is fair, the damages are inadequate, and the both parties have acted properly. It is especially common in a contract involving immovable property, since the land is unique and cannot be replaced with money. Furthermore, equity also guides the court through the principle of fairness and conciseness under Section 11, Subsection A, Specific Relief Act 1950. Specific performance may enforce obligation arising from a trust. However, the court will refuse it if the agreement was obtained by duress, misrepresentation, unconscious conduct, or if it will cause hardship to both parties. The plaintiff must also show the willingness to perform their own part.
So, in this case, consists of three issues. First, whether the plaintiff is entitled to specific performance to compel the buyback. Second, whether there is a tribal issue about the date of vacant possession. And third, whether the plaintiff is barred by equity due to the late payment. Specific performance under the Specific Relief Act 1915 is a discretionary equitable remedy which granted when damages are inadequate and the plaintiff comes with clean hands. Under Order 81 Rules of Code 2012, specific performance can be granted through a fast-track process when the defendant has no real defense. The waiver principle applies when a party accepts a breach without protest and cannot later rely on it. This approach is supported in the case of Bank Negara Malaysia against Muhammad Ismail. So, the application of this case is the court found a strong prima facie case. Evidence such as the notice of vacant possession, tenancy agreement, and rental payments proof delivery on 14 June 2018. The defendant's claim of a later date was inconsistent with documents. The defendant waived its right to complain about late payment because it accepted the January 2019 payment and continued paying rental returns. The plaintiff come with clean hands and the defendant only raised its objection late. The court held that the defense raised were weak and did not create any tribal issues. So the conclusion of this case is the court granted specific performance, ordering the defendant to repurchase the property. Vacant possession was clearly delivered on 14 June 2018 and the plaintiff was not barred by equity because the developer had waived any objection to late payment.
The issues in this case is whether the plaintiff proved actual intentional fraud under Section 44 of the Evidence Act 1950. Secondly, whether her long delay amounted to laches and acquiescence. Thirdly, whether the claim was stated barred under Section 9 of the Limitation Act 1953. Fourthly, whether the SPA was valid and enforceable for specific performance. And lastly, whether D1's counterclaim was proven. There are several laws that apply in this case. Firstly, fraud under Section 44 of the Evidence Act requires a fresh action proving deliberate intentional deception that prevented the party from presenting your case. Secondly, laches bar equitable relief where there is unreasonable delay or acquiescence. Thirdly, Section 9 of the Limitation Act 1953, actions to recover land, including specific performance of the contracts, must be brought within 12 years. Specific performance is a discretionary equitable remedy granted only if the contract is valid, fair and freely entered into. And lastly, courts may reject remedies where consent is doubtful or enforcement would be inequitable. In applying the law to this case, the plaintiff failed to prove fraud. D1's earlier denial of the SPA only showed unwillingness, not intentional deceit. The alleged fraud did not stop her from defending the KFAT proceedings. Her 9-year delay after receiving the 2010 judgment was unexplained, showing laches and acquiescence. The claim was also out of time. Her right to enforce the SPA arose in 2004, but she only sued in 2020, far beyond the 12-year limit. Even without limitation, specific performance could not be granted because the SPA lacked clear voluntary consent, making enforcement inequitable. D1's counterclaim lacked evidence and was dismissed. To conclude, the plaintiff action was dismissed. She failed to prove fraud under Section 44, her claim was barred by laches and the 12-year statutory limitation. The SPA was unenforceable for lack of free consent. D1's counterclaim also failed and costs were awarded to the defendants.
Next, injunction. Injunction is another important equitable remedy. they require a party to either do something or stop doing something, especially when the damage are not enough to protect rights. The court will consider fairness, adequacy of damage, and whether the applicant has acted with a clean hand. In trust situation, injunction protect beneficiary by preventing a trustee from breaching their duties or harming trust property. Next, there are several types of injunction. First, interlocutory injunction, a temporary order to prevent irreparable harm before the trial. Second, quick payment injunction is to prevent harm before it's happened when the threat is serious and likely. Third, Mariva injunction frees a defendant's asset to prevent them from being hidden or disposed of. And lastly, Caterpillar order allow entry to secure evidence at risk of being destroyed. It is only granted in exceptional case.
The issue in this case is first, whether the plaintiff had a good arguable case and local standard. Second, the defendant had asset within jurisdiction. And lastly, whether there was a real risk dissipation and whether res judicata part this suit. The law in this case is Mariva injunction frees asset to ensure they remain available if plaintiff win the case. To obtain it, plaintiff must show first a good arguable case, meaning a claim that capable of serious argument. Second, defendant has asset in jurisdiction. Third, a real risk dissipation before judgment. Res judicata does not bar a Mariva when the purpose is to preserve asset pending appeal, not litigate the dispute. The High Court can grant a Mariva even if the underlying matter is on appeal. For a company in liquidation, a shareholder may sue with the liquidator sanction even if the shareholder is undischarged bankrupt. The plaintiff had local standard because he obtained sanction from the liquidator and the insolvency department despite being a bankrupt. A good arguable case exists because the Johor Bahru High Court had already confirmed the fraudulent transfer and recorded the liquidator's misconduct. The land was clearly within jurisdiction and the defendant was actively developing and collecting the deposit, showing a real risk of dissipation. Defendant argued on res judicata and that the plaintiff should apply at the Court of Appeal were rejected. The injunction aimed to preserve asset, not reopen decided issue, and the High Court had jurisdiction to grant it. The plaintiff established a good arguable case, had local standard, and defendant had asset in Malaysia. There was a real risk of dissipation and res judicata did not apply. Therefore, Mariva injunction was properly granted to preserve the land pending appeal.
The issue of this case is first whether the ex parte Mariva should be set aside for non-compliance with strict ex parte requirements, and the second one is whether a Mariva injunction should be granted to the parties. For the law under Order 29 Rules of Court 2012, an ex parte applicant must strictly explain urgency why no notice was given, what the defendants must argue, and must disclose all material facts. And for a Mariva injunction, the plaintiff must show first a good arguable case, asset in the jurisdiction, a real risk of dissipation, supported by solid evidence and not just allegations. By the case of Lee Kai Wen, it confirms that the main test of the risk of dissipation. For the application to the case, the court accepted that all Kurma had a good arguable case and that the defendants had assets within Malaysia. However, the ex parte affidavit did not give real details of urgency, nor notice reason, or the defendants likely respond, and it failed to disclose material facts. This was not full and frank compliance, so the ex parte Mariva was set aside. For the inter partes application, the plaintiff showed no concrete evidence that the defendants were hiding or moving assets. Alleged dishonesty alone is not a proof of dissipation, so the third Mariva element was failed. In conclusion, the ex parte Mariva was discharged due to non-compliance with strict procedural duties. The inter partes Mariva was also dismissed because, although the plaintiff had a good arguable case, there was not a solid evidence for a real risk of dissipation.